In the previous video cast, we looked at the sources of the law and I mentioned the different types. Now we're just going to look at some of them in more detail, the key ones being administrative law, professional law and civil law. So as I said previously, administrative law regulates the activity of public bodies, and I gave the NHS as one such example. Other examples include CCGs, which are the clinical commissioning groups. Other examples are local authorities and education authorities. Now, the creation of these public bodies was allowed through an enabling act of Parliament, so that had to happen first before those bodies came into being. Regulations made under the Act come with statutory duties on that public body. For example, managing budgets, the employment of staff and entering into contracts. Now, the administrative law is the law that's applied if someone believes that they've been wronged by a public body exceeding their statutory powers, then they can apply to the administrative court for a judicial review. Now, a judicial review is when the court determines whether the public body acted fairly, reasonably and within its statutory powers. It doesn't review the factual basis on which the decision was made, but it looks at the three criteria. One, was the decision taken lawful or not? So therefore, was it within the powers of that public body to make that decision? The second criteria is, was it reasonable and a rational decision? So had the body considered all the relevant facts and ignored those that weren't relevant? And lastly, was the decision based on the correct procedures laid down? So that would be almost like a checklist to see if they followed their own procedures. Now, administrative law consists of statutes, acts, regulations, orders, directions. Now, directions, these are made by senior civil servants under the authority of the relevant minister. And the last thing, it consists of policy statements and guidelines. Initially, the public authority itself usually enforces the law. So, for example, the enforcement of the NHS contract is by the NHS Commissioning Board. Sanctions are administrative, for example, fines, and it can include the loss of contract. The other law that we're going to consider here is professional law, and I mentioned before, this is the law that underpins the power to discipline professionals. So powers are granted to regulators through statute. The Pharmacy Order 2010 and its associated rules are those that are applied by the General Pharmaceutical Council. Now, for health professionals, there's a general idea that we have an expected standard of care. Now, this is used by professional tribunals to judge whether a professional is guilty of misconduct. Civil law, again, that was touched upon in our previous videocast. Now, that's derived from the notion of duties and responsibilities owed between civil citizens, so members of society. It also allows aggrieved parties to sue for compensation from another citizen who is alleged to have wronged him. There are typical cases, civil cases in healthcare include clinical negligence, breach of confidentiality, and treating without consent. Now, the clinical negligence, the claimant makes an allegation that another person, the defendant, has caused them damage or injury. Now, the claimant has to prove on the balance of probabilities that the health professional owed them a duty of care. They also need to prove that the duty had been breached and also that the breach caused injury. Now, the essence of negligence is that there is on part of the defendant a legal duty of care which they failed to meet, and as a result the plaintiff has suffered damage. Now, duty of care means that a healthcare professional must take reasonable care to avoid acts or omissions which they can reasonably foresee would be likely to injure their neighbour or the person that obviously they are treating. So basically, it represents a special relationship between pharmacists and their customers, where the customers are reliant upon the skill and knowledge of the pharmacist. Now, the law expects that the pharmacist should be exercising the degree of competence that the average member of the profession is required to possess, and that's otherwise known as the Bolam principle. A typical example where negligence can come into play or can be seen in practice are dispensing errors, and they can happen quite frequently. Now, most errors relate to the wrong medicine and the wrong strength of medicine. Now, I spoke briefly about the one in the previous video class where Mr. Pendergast was given Dawanil, so diabetic medication, instead of an antibiotic, Moxil, and that was clinical negligence. There are further examples. I'll just take you through another one. We've got the Migral case, which was Dwyer versus Roderick, and that happened in 1983. A woman suffered gangrene in both feet, which required extensive surgery, and as a result, obviously they were cut off. This was as a result of receiving an overdose of Migral, which was prescribed for migraine. The doctor negligently prescribed an overdose, and the pharmacist failed to spot the overdose, therefore dispensing it and supplying it to the patient. The pharmacist was held liable for negligence, and the owner of the pharmacy admitted to that negligence and was held liable for 45% of the £100,000 settlement. The judge emphasised that the pharmacist owed a duty of care to the patient to ensure the drugs were correctly prescribed. The pharmacist should have spotted the error, and they should have queried the prescription with the doctor. So that's how the judge ruled on that particular case, and therefore the award of the fine to the pharmacist. Patients are also able to hold a pharmacy owner vicariously liable for the actions or omissions of a pharmacist employee. So individual pharmacists have an independent duty of care, and the pharmacy owner can claim indemnity from the pharmacist responsible for any error or contribution to any damages payable. Therefore, there's that requirement for professional indemnity insurance, which every practicing pharmacist should have. Now, most negligence cases are considered by the civil courts, but cases resulting in death of a patient may be subject to criminal prosecution. The pharmacist may be charged with manslaughter through gross negligence. Corporate Manslaughter and Corporate Homicide Act 2007. Now, manslaughter charges can be brought against managers, directors and superintendents of companies or NHS bodies. Now, what the courts need to do is determine if the death was due to major failures in the management arrangements, such as staffing, training or resources. The other types of civil cases in healthcare, which are breach of confidentiality and treating without consent, will be dealt with in another videocast later on.